that he can go over and connect you with. So go ahead, Bill.
Okay, good morning, everybody. It's going to be a really quick overview, and of course, you're going to have your questions afterward, and I'll be very accessible to you. I work at the Smithtown Library, and we opened our Patent and Trademark Resource Center way back in 2013. You see the picture here of their opening day. We had so that's me with a beard back then. We had ourselves a handsome contest, and I came in right there up front. Anywho, the gentlemen you see in the middle here are from the Patent and Trademark Office. We are accredited by the United States Patent and Trademark Office. They oversee everything we do, and we do annual training to keep up on all the new ins and outs of patents. One of the things you should know about my library is the Smithtown Library. We are temporarily located, the Patent and Trademark Resource Center is temporarily located at our Wisconsin building. Unfortunately, last month we had some flooding in our main building. So if you're the type who'd like to sit one-on-one with somebody, if you like to learn by watching me and demonstrating right in front of you, you have that option. But this is the time of technology, so you can actually have a meeting with me virtually. And a couple of years ago, I had my very first virtual appointment with a young lady in Europe for the first time, which I thought was pretty wild. She was a Stony Brook student, of course, and she was studying in Moldova. And she decided she wanted to start a travel business. And we had a nice session. We were talking about trademarks. It was 2 p.m. Where I was, I think it was 9:30 p.m. where she was. So you can access me and my resources virtually, or come by and see me at the Smithtown Library in Wisconsin building. And so today we're going to talk about intellectual property protection. I say that there are 4 flavors of intellectual property protection, and you want protection because your ideas is your property. But unlike other property, you can't put your ideas in a wallet, you can't lock it in a locker, you can't build a fence around it. So you're going to have to use one of the 4 flavors of intellectual property protection. And for today's purposes, I'm going to give a demonstration where we're all going to be in the umbrella business. So we have this really cool umbrella, and we hired these really cool artists to give each umbrella, or a series of umbrellas, a really cool look. And as you see here, our umbrella is decorated to look like a watermelon. Kind of fun, kind of neat, kind of different. Well, if I wanted to protect my designs for my watermelon umbrella or my orange umbrella or what have you, I'm going to use a copyright. Copyright is going to protect your artistic works, everything from choreography to song lyrics, films, music. So if you're an artist, you're going to use copyright. Copyright, as soon as you publish anything, is implied. However, if you find someone infringes, steals your work, you have to apply for a copyright at the Library of Congress, and then you can take them to court. A lot of times I get people who are in the t-shirt business, and they come in and they want to they want to trademark. And what it is they're actually doing is they want to copyright because they have a dozen different styles of designs on their t-shirts, and they think they want to trademark. Well, it's actually a copyright. And the reason that is, I'll give you an example. For our umbrella business, we came up with a cool name called Fruits. So we call ourselves Fruits Umbrellas. So the fruits will always appear on my products. And what that is a trademark. A trademark is something that a logo, a symbol, a word, where the consumer goes down to the aisle where he's looking for umbrellas. And within the umbrellas, he sees the fruit brand and he knows who the creator is of that product. If he likes our products, then he's attracted to our logo. And then we have a really good business going because we have created an image in people's minds that Fruits umbrellas are a quality product. And we don't want anyone to steal that from us. So we're going to protect our logo, Fruits, from others by using a trademark. And I'll get into trademarks a little deeper later. Next, our crack team of engineers created a brand new umbrella frame that keeps our umbrellas nice and strong and keeps it from collapsing in strong winds and rains. So that's a new invention. You might have inventions of your own, and how you would protect that would be with a patent. A patent protects any new inventions, machines, articles of manufacturers, compositions of matter. We'll get a little deeper into patents later. Now, let's say you are, our 4th flavor of intellectual property protection is the trade secret. A trade secret, let's say you own a company, we're making our own umbrellas, and your engineers build something along the assembly line that gives you a competitive advantage. It allows you to produce your umbrellas a little more efficiently, faster, cheaper. And if you can keep that a secret within your engineers and your work and the people who work for you, then you can maintain that competitive advantage for as long as you keep it a secret. However, with trade secrets, there's very little recourse other than suing your own staff if they go and share your secret with other companies. You can fire them, you can sue them, but if they're working for you, they're probably not going to be able to pay you the sums of money you might have gotten had your secret been kept. So a trade secret is good, where if you can keep it a secret, it could be kept indefinitely. Companies that enjoy trade secrets are companies like Coca-Cola, Kentucky Fried Chicken, WD-40. But if you have a product that can be easily reverse engineered, trade secrets probably not going to be the best idea for you, because others will be able to see the little secret sauce or what have you. So if you have a company, if you have a trade secret, if you have something you can save amongst your staff, that would be a trade secret. So we're going to dive into patents. What a patent is the United States government gives you a grant. You, the inventor, gives you the exclusive right to make, use, offer for sale, or selling your invention or importing it into the United States. And if someone infringes upon that right, you can take legal action against them. And the US patents are effective only in the US and its territories. What that means is if you have an invention and you want it built and manufactured in China or Mexico, you're not protected in China and Mexico unless you apply for patent protection in those territories. Many areas around the world are patent offices are country specific, like China, United States. Others are regional, like the European Patent Office. There is no one international patents. We just simply can't get all the governments of the world to get along. But there is something called a patent cooperative treaty, where you can file your paperwork with the patent cooperative treaty, and it makes it easier for you to apply and pay patent fees to whatever regions you wish to be protected in. So patents also come in different flavors, 3 of them as a matter of fact. Now, 90% of the time when someone is talking to you about a patent, it's going to be a utility patent. A utility patent is something that has some functionality. It's something like an article of manufacture, an improvement to a device, a new machine. And when you see a utility patent, you'll notice it because it just has these numbers. It's simply a device and numbers as a patent, a utility patent. Next, we have design patents. Now, design patents just protect the ornamentation of a device. When I think of design patents, I think of Steve Jobs. He didn't invent the iPod. He just gave it those really cool buttons and rounded edges, and he was able to protect that ornamentation with a design patent. And if you see a design patent, it's always preceded by the letter D for design. Our third type of patent is the plant patent. If you can asexually reproduce any kinds of fruits, trees, berries, shrubs, flowers, you can get a plant patent for them. And the plant patent is preceded by the double P. Now, the plant patents was the last type of patent that was actually delivered to patent and trademark resource centers in paper format. And the reason that is that the photograph of the patents of the new plant variety, the texture, the color was very important to distinguish it from another invention. However, the Patent and Trademark Office, the Patent Office itself, has stopped issuing color photos to libraries like mine, Patent and Trademark Resource Centers. They're only available in black and white now at the United States Patent and Trademark Office. Also, some other Patent and Trademark Resource Centers around the country, like the University of Maryland, have done everyone a favor by scanning all of the previous patents, plant patents, so you can see the color pictures. And if anyone has any questions about that, I'll be happy to answer them. My contact information will be up at the end of the session. So one of the questions I get when people come and visit me is my patent patentable? Well, to be patentable, it has to meet 4 criteria. First, it has to have some functionality. It has to be able to be used. Some people are vain and they want to add a patent to their trophy wall, and they just get a bunch of nuts and bolts and put them together, and that's called a sculpture, not a patent, not an invention. It has to be something that can be used. And the second thing, you have to be able to clearly describe how to make and use your invention. That'll come later when you're writing up your patent application. Thirdly, it has to be not obvious. It's a little more difficult to explain. So somebody who's skilled in the art gets your patent application, they will have to have said, oh, I did not anticipate that. For instance, let's say a new type of aluminum alloy is released to the world, and you're a bicycle frame maker. If you're the first bicycle frame maker to use that new aluminum alloy and you try to patent that, you'll be denied because obviously other bicycle frame makers would eventually have used that new aluminum alloy. There was no, that was easily anticipated. So that's how you can avoid non-obvious. Just understand that if it doesn't have any kind of surprise moment for anyone who's skilled in the art, it may not satisfy the non-obviousness. Now, the last thing is it has to be new, novel to the whole world. And that's where I come in. If you come and visit me for a patent demonstration, I will show you what we call a preliminary patent search. That is, the US Patent Office recommends that you, at the very least, go through the US Patent Office, the European Patent Office, and the Japanese Patent Office, the three biggest patent offices around the world, before you file your application. Now, sometimes people ask me, is this a good idea? I can't tell you that. So a couple of things that I can't do is give you business advice, and I can't give you legal advice. I can help you find business partners like the Small Business Development Center who may be able to tell you if this is an idea that may have some footing and can be done. But again, I can't give you business advice because who am I? Who would have thought that the pet rock would have gone so far and made someone millions of dollars? One of my favorite inventions are inventions that don't have any moving parts, like the plastic wishbone. Next month, we'll be selling Thanksgiving, and traditionally families fight over the wishbone. Well, a gentleman came up with the idea of a plastic wishbone, and others might think that's silly, but that gentleman sells about 2 million units every Thanksgiving. So that's a living, a pretty good living. So why do I need to search? Well, what you're looking for is prior art. Remember, your invention has to be new, not just to the US Patent Office. It's got to be new to the whole world. If your product is being sold anywhere and the patent examiner who receives your application, he or she is going to be an expert on that product. So let's say umbrellas. You have an umbrella patent application. It'll go to a team who works specifically on umbrellas, and they will know all the trade shows, the trade magazines, and certainly all the patent offices are all over the world. And even if there are scientific papers on your technology, if they can find that it exists anywhere, that's prior art, could deny you your claims for brand new invention. If that invention does already exist, you do not get refunded. Your application fees will remain with the patent office. However, if you don't bother doing a patent search and you go ahead and build that product, you might be infringing on somebody else's intellectual property, which means you'll get a cease and desist letter for you to stop making that. Now, really quickly, a patent is kind of like a hunting license. What will happen is if you get a patent, you get protected, but it doesn't mean that the patent office is going to come knock on your door and say, hey, someone's infringing upon your patent in Wisconsin, or they're coming over the border in Mexico. You have to police your own device, your own industry. And if you find someone who is infringing upon your patent, you can send them a cease and desist letter. You can take them to court. And if you take them to court and you win, the judge will award you, well, they'll have to stop making your device, which will cripple them because they've had to advertise it and manufacture, deliver it. But they also have to pay that you will be given a 5% of their proceeds as a penalty. That doesn't sound like a lot, but 5% is the general amount of money you would make if you were to license your patent. Because a patent is a product. You can will it to your next of kin, you could sell your patent, and you can license your patent, meaning someone else will develop your product for you, and usually you get paid quarterly, and that payment is usually about 5% of the proceeds. Now, if someone infringes upon your patent and you can prove that they infringed on it purposely, knowingly, the judge may award you up to 15% of their proceeds, may award that your opponent will pay your legal fees, and of course, they have to stop making your patent. But most likely you can work out a deal since they're going to be so far into their process of tooling and manufacturing, fabricating and selling your product, you can probably work out something with them. So that's the benefits of having a patent. Now, to do your search, where are you going to search? Well, Again, the Patent Office recommends that you start with a preliminary patent search, which includes the US Patent Office, the European Patent Office, known as the SPASNet, and the Japanese Patent Office. And there is a bit of a timely issue. What we have now is a first to file system. It's a first inventor. So if you have an idea for a brand new umbrella to improve upon it, and so, there could be other tinkerers, entrepreneurs, businessmen, women all over the world who may have that same idea. It is the first one to file that idea at a patent office. And as long as it is articulated correctly and well enough to protect the new innovation, it is most likely the first person to file that who will get the patent. So there is a timely issue. One of the reasons why the patent offices recommends that you search the top 3, file your patent application. And what's really nice is the first step in patent protection could be something called a provisional patent application. So it's not a patent, it's just an application. But what it does, it timestamps when Bob Harrison had his idea for his new umbrella. So that now you have a timestamp of the date that you had this idea filed. Now you can start talking to fabricators, manufacturers, business partners without the fear of stealing your idea because you have that file date for your provisional patent. That file date also becomes a deadline. You have a year's time from that file date to file your regular patent application. And should that regular patent application finally get granted to you, your protections are backdated to that original file date of the provisional patent application. And I can make much more sense of that if you want to call me, email me, or come and see me. But remember, we're not going to stop at these 3 databases. You got to check all over the world. And so there are lots of databases you can visit. And today, you should also check any marketplaces, do Google searches. I've personally found inventions that I thought I had on Google Images. So search everywhere you can and really exhaust any databases you can before you go making that filing for that regular patent application. But today, we're going to explore the US Patent Office. So I'm going to share my screen. And right now, you should be at the US Patent and Trademark Office. Okay. So thank you, Leslie. It's much friendlier looking than it used to be. It used to be very industrial and clunky, but for newcomers, it's probably still going to look industrial and clunky. It's a lot of information out there, and making sense of it can be quite the task. So for a patent search, before I go into patent searching, if you're going to do business with the USPTO, you want to open up a My USPTO account by clicking here and simply need an email address. When it's time to file, there are some other papers that you have to file with them. Some of them have to get notarized. I can tell you more about that if you meet with me individually. But for now, I want to give you a little taste of the actual searching for prior art. To do that, we're going to use this Find It Fast button over here on the right an awful lot. When I hover over it, I get 2 columns. We're going to just disregard the trademarks for now, and we're going to come over to patents. And the first item on the dropdown is Patent Public Search. Let's explore that. Here we are. The Patent Public Search is a fairly new database. It was released about 3 years ago, and the Patent Office was very excited about it because it took several patent databases that were separate, that involved separate searches, and it brought it all together. The idea was to have one single patent database for both examiners and everyday people, inventors, to use. It didn't work out. They just couldn't work it out. So the patent examiners still have their own very own more powerful database, and the public is left with the Patent Public Search. Unfortunately, it was designed kind of with the patent examiner in mind. So when I show it to you, it's going to look a little intimidating, but we'll work it out and I'll explain what it means. It was a little so intimidating that shortly after they released the Patent Public Search, they decided to offer a basic search, as you see here. So we have an option, basic search or advanced search. I'll show you what the basic search looks like really quickly. Okay, so now we're in the basic search. And the first thing you notice is we have to make a decision. We have this or option here. So if we're looking for our umbrellas, we can start here. But as you see, it's asking for a patent or publication number. that's not going to help us out when we're starting out for our search to see if anyone's copied our umbrella. It might work out if your uncle tells you I invented the elevator and he gives you a number. Fantastic. You can type it in there and find out. But for right now, it's not going to help us out. So let's move on to the or option, the bottom option. Well, there's an everything search. So I can type in the word umbrella there. And it gives me an operator. We're going to leave it as and I'm going to put in another term, let's say wind. And the operator here in the middle tells the database how my two entries are going to be, not wind, going to be related. It's going to tell the database to look for the word umbrella and wind. And my option is everything. So I click on search. And I'm going to get quite a few hits, 7,138. That means that the database found that many patents that have both the word umbrella and wind. That's not very specific, and that's a huge number. Time is money. I don't want to look at all of those. So we're trying to get a little more specific. Now, unfortunately, my other options in the basic search are hyper-specific. Applicant name, that's not helpful. Assignee is the owner of the patent. Attorneys, no. Attorney name. Application number again, no. The inventor's name. Publication date. These are all so hyper-specific, it's not going to help with an initial search. So I'm going to recommend you start with the advanced search. To do that, I'm going to click on this home icon, and we're back to our beginning page. Now let's take a look at the advanced search. I do that by clicking on this advanced search link, and here we are. It's a little intimidating. Here we have 3 different panes or windows to look at, 1, 2, and 3. They all have a different function. The first window here, and these can be manipulated to suit you. So I'm going to slide that over there, and I'm going to make a little more room for myself. And here is where I'm going to enter my search terms. Let's go with what we had used earlier, umbrella. Let me just take off the caps lock. And wind. And let's throw in the word resistant. So that's where I put my search terms. Over here to the right of the search term is the databases I want to search. You want to keep it select, you want the select all feature to be checked off. That way it'll search all 3 of the databases. And the 3 databases are here. There's a US pre-grant publications, which used to be the application database, a separate database. Then there's the US patents. That's the huge database of 12 million patents. The patent office is very proud of themselves. They had 12 million patents. Wonderful for them, not so good for me, the inventor, who wants to whittle it down just to umbrellas. And then there's this new database, the USOCR. It stands for Optical Character Recognition. That means that all of the previous patents dating back to 1830s have been scanned in and and now they can recognize the text when you put in a search term. So you can do keyword searching, which was not available before 1976. Now you can do keyword searching all the way back to the 1830s. And the reason you want to go back that far or even beyond is once something is patented once, it can't be patented again. The umbrella was invented years and years ago, but there are still umbrella inventions coming out. Those are improvements to the umbrella, changes to the umbrella. The umbrella itself cannot be patented once again. Over here, we have our operator again. The operator is defaulted to the word or, that means it's going to find inventions that have the word umbrella, wind, or resistant in it. The highlights, when we get our results, we can choose to highlight all of our search terms, umbrella, wind, resistant, in different colors for easier searching. So let's do a quick search and see what kind of results we get. Here's my search button here. And as you see, the other 2 windows have populated. So let's take a closer look at what we have. First, we're going to look at our results window here. As you see, my search terms came up in different colors. Now, there is a huge amount of information here. Way too much more information that a newcomer would need who's performing a quick or trying to perform a quick search. So let's whittle this information down. To do that, we can click on the settings button here, or we can click on the plus sign here. And what you'll see is we can start checking off some of the columns that we don't need. For instance, these numbered columns, document ID, I'll keep. Family, I don't care how many pages right now at this point. I do want the inventor. And as you start unchecking these boxes, you'll see that the amount of information becomes a little more easy to digest, because right now, I just want to look at the basic information. So now I've got a lot less information, but I don't like the way it is organized. For me, the title is really important. So you can click and drag the title and set up your search however you like. The title page is taken up, the titles have taken up way too much real estate. You can click on the side of the title column, drag it over, make it a little shorter. And for me, I think the inventor might be really interesting. So I'm going to click on the inventor column, click and hold, and I will drag that over. And now my results are a little friendlier to me to work with. So I'm going to drag this final pane or window over. And now, as you see, when I click on a certain invention in this column of my results, it populates into this final window, which is our document viewer. So let's find one. Let's see. Let's just pick one at random. Exercise bike. And it populates over in this final window. Let's get a little better view at the document viewer. The document viewer, this is the actual patent document. It'll have the title. Patent titles are rather bland. It's difficult to search by title unless you have a specific patent in mind. You have your inventor's name and location. These are the classifications. We'll get into that later. Next, we have the abstract. The abstract is a basic summary of the invention. Whatever's really important to do with this invention, it ought to turn up in the summary, in the abstract. Next, we have the background and summary. This is where the inventor is saying, you know, the state of the art of exercise bikes takes us to this point, but I have invented something that will allow us to do X, Y, and Z, and this is why my invention is really valuable. Then we have our description. The description is going to be of the drawings, which we're going to see later. And then finally, we're going to come to, and as you noticed, whenever our words come up, they're highlighted. Finally, we come up to the claims. The claims is the metes and bounds of what it is you're being protected for. In the claims, you have to describe how your invention is made, what it does, and what the end result is. So this inventor has 10 claims. Usually patents will have 20 or fewer claims. The patent examiner has to meticulously go through your claims and make sure they don't exist anywhere in any other product. So the more claims you have, the more work for the patent examiner. After 20 claims, they'll actually have to charge you for any extra claims after 20. Now, let's take a better look at this document viewer. You might have noticed we have this toolbar up here, and the first item on the toolbar is the text/camera view. Now, I know that you've heard the term picture says 1,000 words, and when it comes to patent searching, I really think that a lot of inventors like to use the drawings to get a really good glimpse of what this invention is all about. So if we click on that, we actually get the actual scanning of the patent. A little further down on the toolbar, we click on this double arrow, and it'll increase the size of the document. And we can take a quick look. And by taking a quick look, I can see this really has nothing to do with my umbrella invention. So I can move on to the next invention, and the next, and the next. So that's a brief overview of the different windows we're looking at. Now let's talk about our results. Right now, I have quite a number to work with. I have about 2 million patents here. Way too much for anyone to look at. So let's see how we can whittle that down. So we're going to whittle that down by going back to our search page here, our search window. So the default operator is defaulted to OR. We have options. We can default it to AND. and will force the database to find these 3 words, umbrella, wind, and resistant, in the same patent. And if I do that, I'm down to 0 results found. Well, let's see, that shouldn't be, but all databases.
Well, there are 3 L's in umbrella. That's why.
Oh, thank you. Wow, Leslie, you're good eye. So umbrella, wind, and resistant, if I use the and feature, it's going to whittle it down to, I have 1,800 results here. Still quite a lot to look at. And the other options are the adjacent option. The adjacent option will search for patents that have these 3 words in that order. I click on search, I have 1 result because nobody really speaks this way, umbrella, wind, resistant. So that's not going to be a good option. Remember, you're trying to uncover every stone, but you're trying to be efficient. You're not trying to make your search as easy as possible. You just want to be able to get relevant results. So adjacent may not be good. Then there's near. It finds those 3 words in any order next to one another. We have 1 result. We have same. These will be the same, those 3 words in the same paragraph. Now I have 218 results, not too bad. But there's also with, these are the same 3 words in the same sentence, and we have 155 results. So let's work with that. So as I'm searching, I see umbrella, wind resistant, parasol. You click them, you do your due diligence, you go through all of these patents. You take a look through the patent, review the images, use the toolbar to page forward within the document. You can use this toolbar to skip documents. And every time you find a patent that may have something to do with your invention, you do your due diligence, you're taking notes, you write down the patent number, you write down the inventor's name and the file date. And you're going to submit that, all of those patents you find, along with your application to show the patent examiner you've done your due diligence. He or she will look at all the patents you found, also do a search of their own. Now, this has all been well and good. People love to do keyword searching, but there is a better way. There's something called classifications. So I work in a library. Classifications like the Dewey Decimal System work very well. If you were to approach me at the reference desk and you said you needed a cookbook, I will give you a call number 641. You go up to the stacks, look at the binders, and you look at the call number 641, you'll be in front of all the cookbooks. Same concept with the patent office. They get thousands of types of gizmos thrown to them every year, from mousetraps, umbrellas, fuel cells, rocket ships. All of those inventions are going to be pushed and prodded into a classification, sometimes several classifications. So me as the inventor for an umbrella, I want to find the classification that really speaks to my wind-resistant umbrella, so I can be certain that I'm getting all of the patents that are out there. Because keywords are fine, but some people use different words for the same invention. For instance, we're looking for umbrellas, but earlier here we found an invention called same thing called a parasol. So we want to make sure we're covering all the bases. So really quickly, I'm going to show you how to add a classification system. Okay, so I'm just going to add another window. Bear with me just a moment. So let me know, Leslie, if I have returned to the homepage.
Yes, you have.
Excellent. Okay, so now I'm interested in finding what classification. To do that, I'm going to go back to my Find It Fast button. I scroll over the patents column, and I scroll way down to classification. Here in this template, I'm going to put a description of my invention. Let's put in umbrella, wind, search, and these are my results. What I'm looking for is CPC schemes. CPC schemes. This one includes the word umbrella, so I'm going to click in it. And these are my results. I have this column of CPC classifications. They're just a bunch of numbers and letters, all kinds of gobbledygook. The next column is the descriptor. So now you're data mining. You're drilling down to which one of these descriptors really speaks to your invention. So here we have sticks combined with other objects. No, Walking sticks or umbrellas convertible into seats. Interesting. No, you're going to learn a lot about your industry. Umbrellas characterized by their shape, perhaps tiltable umbrellas. Eventually, you're going to come across something like, let's see. Aha, devices for increasing the resistance of umbrellas to wind. That sounds like it's going to work. Now, it corresponds to this classification, A45B 25/22. Now, over at the patent office, they joke around that they speak patentese, combination of legal speak, engineer speak. So I want to get a definition, a stronger definition of what this classification is. To do that, I'm going to click on the D here on this column, which is going to give me a definition of this classification. And it looks to me that it is a umbrella beaten about by wind and rain. So I like this classification, my A45B 25/22. So what I'm going to do now is I'm going to go back to my search. Find it fast, patent public search, advanced search. Now this time, I'm going to throw in my classification. I get rid of all spaces. Now the patent database doesn't understand what that number is going to be unless I tell it. There's a specific syntax you have to use. Anytime you put in a specific term, you have to include a dot, and then you have to give it a command and a second dot. The commands, you will find them by clicking on the Help tab here in the results page, and you have all this wonderful information, including what we call the field tags. So here's the field specific searches. So the classification that I'm using here is called the CPC, the Cooperative Patent Classification, and the sample they give us is the classification number followed by a dot, CPC dot. So that's what I will use to communicate with the database. I have a dot, CPC dot. I click on search, and now I have 443 results, and I know that all of these results will have to do with wind-resistant umbrellas. And you do your due diligence, you go through all of them to see if any of them has beaten you to your umbrella technology. Okay, I know that was extremely detailed, but we, of course, if you come visit me at the Smithtown Library, visit with me virtually, I will go over it in much more detail slowly, and it'll be much more digestible. And it's really to your benefit I don't discourage anyone from hiring an attorney to do this kind of work for you, but if you learn how to do it, take some time to do it, many people find that their invention already exists, which is bittersweet, but you can also find out how much you have to tinker with your invention to work around the existing technology, or that might be at the end of the road. Either way, you could have saved yourself quite a lot of money in fees for doing some searching on your own. And then if you decide to hire an attorney, then you'll be better informed about what your attorney is going to be doing for you. As a matter of fact, if you're going to be hiring an attorney, I will really quickly show you where you can find one that is able to do this kind of work. In addition to passing a bar exam, a patent attorney has to pass another exam to become a patent attorney. So if we visit the uspto.gov website, we can use their search box and we can type in registered attorney. In the results, you can click on search for registered patent attorneys and agents, find a patent practitioner. It's all fairly intuitive. And I can tell you now that in the Long Island area, the hub of intellectual property protection seems to be in Melville. So let's see if we type in Melville, New York, search, we're going to get 80 plus attorneys in the area. Eventually. That's true. Oh, here we are. It's just a delay. So the status here, patent attorneys, sometimes you'll see agents. Agents they did pass the exam to become a registered patent practitioner, but they don't have the law degree. Several firms will have both attorneys and agents. You can cold call all of these people to see who you may want to work with. Agents may be a little cheaper. Okay. Now we're going to move on from patents to, let's see. Just bear with me while I try to get back to my presentation. Mm-hmm. Sorry, folks. Okay, so we're going back to the presentation. We've discussed patents, and now we're going to discuss trademarks. So a trademark is generally a word, phrase, symbol, or design. Basically, it's a logo, your brand that's going to appear on your products. Earlier, I gave the example of t-shirts. If you have a t-shirt brand and you have the same logo that appears in the t-shirt, it's that logo that appears will be a trademark, not the images that appear on the different images that appear on your shirts. Now, under trademarks, you have 3 different levels of protection. You have your common law, state, and federal. These marks that you may have seen, the TM and the SM, are free. You can start using them right away. You can put the TM for tangible goods. The TM is for trademark. Tangible goods meaning anything that you can touch. Your pens, your water bottles, your laptops. Then there are SM marks. SM is service marks, services like legal services, financial services, those kind of things. You can put the SM next to your logo. They both fall under the umbrella of trademarks. And with these trademarks logos that are free, the TM and the SM, they're all well and good because it's telling people in your industry you're interested in protecting your intellectual property protection. But what you're really working towards is the encircled R, which means that your trademark has been filed with the Federal Trademark Office and you've been granted a trademark. The trademark meaning that you can exclude anyone from using anything that sounds, appears, or means like your mark in that industry. So the strongest kind of a trademark is a word mark, where you're just protecting the words that in your logo, no matter how it is stylized, whether it's bubble letters, script letters, and such. So here are a few examples of what word marks are. Many people like to use symbols, and you can use symbols as well. Logos, designs. Sometimes you combine the two. Trademarks can be both word marks and designs. Trademarks can also be colors. It's very rare, but for example, the UPS company has gotten a trademark for the color brown on vehicles. And you can actually get trademarks on the shapes of things like the Pizza Hut building can be trademarked. So I know we're really running low on time, so I'm going to quickly get us back to the USPTO website.
Actually, Will, we're here till 10:30 if you'd like.
Okay.
If people have to leave early, they can, but we're scheduled till 10:30.
All right, great. So do we have the USPTO homepage back on screen?
Yes, we do.
Now we're going to explore a little bit about trademarks. If you own a business, you're going to own a business, you have a mark that people will go to the marketplace, they go to the aisle, they recognize that mark, they know who the source of the product is. If you have a good reputation for yourself, you don't want some clown next town over or next state over stealing your customers by using similar marks. So you can protect it with a trademark. Trademarks will last indefinitely so long as you're still in commerce, meaning if you get a trademark for umbrellas and you continue making umbrellas and using that mark and selling umbrellas, you can keep it. But let's say your umbrella line's not working so well, you start making raincoats. Well, if you're no longer selling umbrellas, you can't keep that trademark. And if you're making raincoats, you may have to get a trademark, but that could be a separate class of goods, so you may have to file a separate application. Right now, let's take a look at searching. What we're doing is basically a clearance search. Before you go wrap your van with your logo and get a URL, do a little bit of a clearance search just to make sure you're not infringing upon someone else's trademark. To do that, we're going to visit the Find It Fast button once again. And this time, we're going to go to Trademark Search in the Trademarks column. This is a brand new database launched last November, and it's going to allow you to do what they call regular expression searching. We'll get to that later. First, we'll start with our logo. Leslie, what is your high school or college mascot?
It's really stupid. It's a surfer. We will call the Riverhead Blue Waves.
Blue Waves. Okay, we'll go with Blue Waves. Or we'll just go with Waves to make it a little easier. So if we type in the word waves, we're going to get quite a few hits, 10,000 hits. So we can revise our search by putting in our product. So let's say we're going to go with surfboards. Now we're down to 89 results. And you can manipulate the layout. Right now we have this nice tiles. Over here we have a toolbar where you can change the layout to more of a listing view and still a little smaller. But I like to use this layout because you can see your marks a little easier. Now, this all sounds well and good and pretty easy, but the biggest mistakes that people make is when they're doing a trademark search is they just simply type in the exact spelling of their logo and product, and they think that if they find nothing, they're okay. But remember, we're working with the acronym SAM, S-A-M. We're looking for any products that sound, appear, or mean the same thing. For instance, you've been to the CVS, you've been to the oral care aisle, and you see your Crest toothpaste. Another company came out with Crescent. They were denied a trademark because it sounds and appears too much like Crest toothpaste. So we got to look out for those. Also, different meanings in different languages. I don't know how, you probably know the energy drink Red Bull. I don't know how good your Spanish is out there, but another energy drink company came out with a product called Toro Rojo. It's simply Red Bull in Spanish. They were denied a trademark because of the meaning. So to account for sound and appearance and meaning, we're going to use what's called regular expression searching. And to do that, we're going to switch to the expert search over here. So to activate the regular expression searching, we're going to use what's called field tags. Now, one of the greatest field tags you're going to use for any kind of word mark is CM, which means a combined mark. It'll look for the word mark and that word in any specific areas of the trademark document. Whenever you're using field tags, you're going to capitalize them. So the syntax will be CM for combined mark, followed by a colon. After that, you can put in your terms. Let's try the word waves again and see how many hits we get. Now we're up to 1,600 because it found waves in different areas of the trademark. We're also going to be concerned with alternate spellings. So this is where the new regular expression comes into play. The syntax for regular expression is you're going to start with your field tag, CM, and then your colon. Now you're going to add a slash at the beginning of your search and a slash at the end of your search. That is telling the database that you're going to use regular expression searching. And what regular expression searching is, you can put in sound alikes to substitute some of the characters or several of the characters in your search. So for instance, let's say somebody decided to play around with the spelling of waves. They could just use a different character for the letter A. Well, I can replace the letter A with a period, and I'll get a few more results because now it can come up with wives or what have you. Now, let's say I'm worried about anything that sounds like the letter A. What I can use is I can use an open bracket, and I can put in any characters that sound or could possibly replace the word A. Maybe A, E, I, Y, close bracket. Now, what I want to do is I want that to replace one character only. So I can tell the database how many of these characters may be replaced. Now, to do that, I'm going to use the squiggly, and I'm going to put one character in there, possibly two, and squiggly. What this is going to do, it's going to look for the word waves, but it can have any one or two of these characters in them. When I click on search, now I get 2,107 searches. So as you see, I got wives here. Wives comes up a lot. Waves, wives, cool waves. Hondo is meaning that's wave in I believe in Spanish. Weaves came up as well. So again, when it comes to your searching, you're not trying to make your search as easy as possible for you, but you also want to be efficient. So what we can do here is I have a pretty good idea that I'm going to cover any variation of the word waves here. So now I want to whittle it down. To do that, I can click on beneath here the search builder. And one of the things I'm going to build by is I want to limit to my international class. What international classes are is the business community realized that if we give the word, let's say, for instance, Dove, as in Dove soap and Dove chocolate bars, if we were to trademark the word Dove and give it to one of the companies, then no one else in the world or in the country could use the word Dove. We would run out of terms for our products. So we came up with, and the big countries around the world got together in Nice, France, came up with international classes. They broke down all goods and services into 45 classes. So now I'm more concerned with our Wave surfboards. I don't care about Wave soap, Wave tires, or Wave computers. I really just care about other surfboard companies. So I can whittle my search down to relevant companies by using one of the international classes. So when I click on this box here, I'll get this drop down, and one of the items in the drop down will be international class. I select international class. I get this other template, and from within my international class, I get a listing of all 45 of them. And I try to figure out which one perhaps would have surfboards in them. And let's see. Perhaps toys and sporting goods. So now when I click on my search, I'm going to have my mashup of the word waves and my international class that includes toys and sporting goods. And oops, my apologies. Search, and now I'm down to 64 results, which is a much easier search to look through. And then I look through to see if anyone has beaten me to my waves surfboards. So here has brain waves. They are an international class 028, but it has more to do with playing board, a playing board with movable pieces. Sounds like a board game. Summer waves, sounds alike. But it has to do with inflatable pools, recreational use, and swimming pools. So this is, you go through your list, and sometimes you're going to see items that are canceled, items that are dead. This means that canceled means they canceled their application. Dead means that they may have abandoned their product and no longer making that product, so they can't keep that, or they stop making payments. So you can actually get rid of all the dead marks by using yet another field tag. And when you add field tags, you're going to use one of the operators we spoke about earlier. In this case, we're going to use the AND operator, and the field tag for live and dead is L or D, and the field tag and the description for marks that are still active is true. Again, this is very detailed, and when you visit with me, we'll focus on either patents or trademarks for my demonstration, and it'll make a lot more sense. So I click on true. Now I'm down to 23 results that have the word or some kind of amalgamation of waves that has to do with sporting goods and that is still in force. And you go through and you see if anything's going to be in contention. If you find some of that may be similar, it's not exactly dead in the water, because the patent office, U.S. Patent and Trademark Office, the attorneys on the trademark end, they will take a look at two marks that could be conflicting, and they will consider price points and clientele to see if those two may coexist. This is the part where you may get an attorney to help you determine if that's worth it. because once again, once you file for a trademark and it turns out that the trademark is denied, it may be that it's you can try and work around it, but you don't get your refunds. So really quickly, a word before you go ahead and choose a trademark, a really quick word about strong and weak marks. You want to be distinctive. You want to be something that people cannot try to copy and not be too obvious. So the strongest marks are arbitrary words. These are words that are, they have dictionary definitions, but they may have nothing to do with your product. A good example would be Apple computers. Apple's for talking about produce, and then computers technology. They have nothing to do with one another. That's why Apple was a very strong trademark, because if some other company came up with applesauce computer components, that's very easily sounds and appears like Apple. They would have been denied a trademark. And if they gone through with that, they could have gotten a cease and desist, an infringement lawsuit from Apple. And the other strongest trademarks out there are fanciful words that are made up, like your Exxon, your Xerox, your any kind of thing. These are words that don't have dictionary definitions, that are very distinctive and are easy to trademark. Words that are difficult to trademark are surnames. If your last name is Smith and you make furniture, you can't stop other Smiths who make furniture from using their own surname. The exception is if it's a very unique surname, like Orville Redenbacher was able to trademark his name, or you're probably thinking, what about McDonald's? It's a common last name. What happens is with McDonald's is, well, first it helps to have deep pockets, but if you file for a trademark and it is not accepted, it goes on what's called a secondary list. It'll stay on the secondary list for 5 years. In those 5 years, if you're able to convince the trademark office that your product and your name, McDonald's, is synonymous in the consumer's mind, they may be able to grant you a trademark for that. But again, deep pockets really help. So you generally want to avoid surnames. Another thing you want to avoid when it comes to a good trademark are words that simply describe your product. So if you're selling cheeseburgers, you don't want to put cheeseburger in your trademark, because you won't be able to stop other companies from using the word trademark. You might be able to be somewhat descriptive about cheeseburgers, but you can't stop other companies from using simple words that describe their products. And again, trademarks can be used indefinitely so long as you're in commerce. Okay, and also with the international classes, if you are a cheeseburger company and you also sell t-shirts and frisbees, you have to take a look to see which international classes your products would fall under. If they all fall under the same international class, wonderful, it's one application, one fee. But if your products happen to fall in several international classes, it's up to you if you want to protect those international classes with separate fees and applications for those products. All righty. I think, Leslie, I'll take any questions if you have them.
No, no one has any questions. I had 5 of them and you answered all of them. That's why I didn't even type them in, just wrote them down. But yeah, this was really, really enlightening.
Thank you. Yeah, this is the tip of the iceberg, of course. It's in about an hour or so. It's hard to give you a really good demonstration. But again, folks, if you want to try to contact me, and I keep losing my my slides, but while I'm looking up my own slides, if anyone has any other questions, or if you or Bob have any questions.
Hey, Bill, with the these are things I found out after we had a patent in place, but can you talk about PCT and also the maintenance costs to maintain a patent as active?
Sure. So the PCT is a patent cooperative treaty. It is an easier way for you to file for your patent in other parts of the world that you think you're going to have a business interest in. It does require separate fees for each part of that world. But when you file for a patent, patent examiners are going to look worldwide to see if your patent is already exists for prior art. So if you are granted a U.S. patent, or you believe you can get granted a U.S. patent, it is very likely you can get patented in other countries of the world or regions of the world. And as far as the fees, you get a 20 years patent for your utility patents and your plant patents. Design patents will only last for 15 years. And the fees start coming at 3.5, 7.5, and 11.5 years. They steadily increase. They do change from time to time. But by 3.5 or 7.5 years, you're probably going to have a pretty good idea if you want to hold on to that trademark. I'm sorry, that patent.
Good. And I had one other interesting client case where I have a client, she's a dental surgeon. She invented a way that she can do essentially implants in one sitting instead of three. And this debate ensued. We had that Center for Biotechnology over here at Stony Brook, and there was a patent attorney there, and she was meeting. And apparently her formulation that she was working on to kind of set, so the bone can harden, you can drill at the same time, that kind of thing. One was a patented material, and she was adding a second component to that. And they had a big debate over whether that's patentable, because she needed the patented component along with her new formulation to make it all work. And the guy at Center for Biotech, now, oh no, you can't do that. But her attorney was saying you can. That's, we're talking about obvious, novel. I mean, that's kind of an interesting discussion, on patentability.
Right. When you're patenting, you're also going to keep in mind the feasibility of building a business around the patent. So if you're using proprietary technology and building upon that, you're kind of picking yourself in a corner because you'll only be able to use your patent by infringing upon others. Therefore, your market for your new patent will probably just be the 2 or 3 or dozen companies that you're infringing upon.
Yeah, the interesting thing is the original patent she was using as part of her formulation was not related to dentistry. So I don't know, interesting discussions that happen, and that this is just what you run into depending on the industry and the patentability factor of what you're inventing.
Yeah, sometimes people combine different things and they want it to be an invention, but the general rule, and again, I'm not the authority on this, is that you can take let's say a broom and add to it a dustpan, and then you add a third element to. You have to have I believe it is at least 3 different elements that you add to existing patents, existing items that are not in force, to consider it a new invention. But you still have to pass the non-obvious criteria.
Okay, good.